Welcome to our YouTube video series on employment law. My name is Christopher Neufeld of Neufeld Legal, and in this particular video we will be looking at a commonly asserted rule of thumb that a fired or terminated employee is entitled to 1 month's pay as severance pay for every year of service with a particular employer. The computation of the appropriate common law severance pay is premised on what the applicable notice period is for a fired or terminated employee. And what we find frequently bandied about as a rule of thumb is 1 month's notice per year of service, which effectively means 1 month's pay per year of service. But is this an actual rule? Justice Devlin in the 2020 Alberta Court of Queen's Bench decision in Brown v. Hrt Motors Inc. stated that, quote, "As is usual in a case like this, the parties have provided me with a series of previously decided cases which they believe have approximately similar facts. These serve to create a matrix of precedent from which the court then triangulates an appropriate notice period for the specific and unique facts of the case before it. By its very nature, this task is always somewhat subjective, but the court works to align each result as closely to other similar cases as facts and circumstances allow. A rough guiding principle in this realm is that notice will generally be in the range of 1 month per year of service for individuals who have served for any meaningful length of time," end quote. Nevertheless, it must also be remembered that the court has repeatedly sought to dissuade parties, in particular terminated employees, from simplifying their analysis to a rule of thumb of 1 month's notice for every year of service. Be it Justice Yamauchi and Lederhouse v. Vermilion Energy Inc., Madam Justice Dario and Smith v. Vauxhall Co-Op Petroleum Limited, or Justice Neufeld's 2017 Alberta Court of Queen's Bench decision in Freeman v. PetroFrontier Corporation, where Justice Neufeld stated that, quote, "The parties discussed the so-called rule of thumb of 1 month per year of service as a measuring stick. This principle has been rejected by some courts, citing Crisall v. Western Pontiac Buick GMC 1999 Limited. This court agrees that this rule is neither warranted in principle nor supported by authorities, citing Minott v. O'Shanter Development 1999. This court is of the view that the better approach is to examine the Bardal factors and arrive at an appropriate length of notice from a principled perspective," end quote. To present this better approach, Justice Neufeld drew upon the summary of the Bardal factors from Nelson v. Champion Feed Services Inc., which was taken from the Supreme Court of Canada's decision in Bardal v. the Globe Mail Ltd. Number 1, the nature of the employment. The more senior the position, the longer it is likely to take to find the replacement position. There are fewer senior management jobs around. Number 2, the length of service. The longer an employee has worked for one employer, the more difficult it may be for an alternate job, either because the employee has narrowed his or her skills by working for one employer for a long time, or the employee has been paid more than the job is worth because of long service. Number 3, the age of the employee. The older the employee is, the less likely he or she is to find the suitable position, or the longer it is likely to take. Older employees are sometimes perceived as less worthwhile to invest in. Number 4, the availability of suitable, similar employment having regard to the employee's experience, training, and qualifications together with surrounding economic circumstances. What is the realistic prospect of this employee getting a similar replacement job? What is the job market like? In good economic times, jobs may be plentiful and the employee may have little difficulty finding a good replacement job. In poorer times, there may be few jobs around. Now, with that being said, we must not necessarily look at the court's refutation of this perceived rule of thumb as being the basis for pushing downward on notice and severance pay, and instead need to look at Madam Justice Moen's 2018 Alberta Court of Queen's Bench decision in Jones v. Temple Real Estate Investment Trust, where she referenced a number of cases presented by the terminated plaintiff and stated that, quote, "It is apparent that cases show some inconsistency, but it is not uncommon for an employee to be given more than 1 month for each year worked," end quote. Quote, "Mr. Jones, the terminated employee, provided a table of cases which gave a range of notice periods where the plaintiff was in the 40 to 60-year-old range. A 40-year-old general manager with 19 years of experience was given 24 months notice, citing Bovin versus Over the Rainbow Packaging Services. B, a 57-year-old purchasing manager with 28.9 years service was given 27 months notice, citing Mitchell versus Westburn Supply, Alberta. C, a 53-year-old divisional manager with 11.2 years service was given 17 months notice. Case Singer v. Nordstrom Equipment Limited. D, a 47-year-old general manager with 22.5 years experience was given 16 months notice. Case Fuhrer versus Tormont Industries Limited. E, a 46-year-old district manager with 12 years service was given 16 months notice. Case Christie versus City Financial Canada Inc. And F, a 42-year-old operations manager with 21 years service was given 21 months notice. Case Narduli versus CW Agencies Inc. With respect to Mr. Jones, Madam Justice Moen provided the full amount that he had sought, which is the top line maximum of 24 months of notice/severance pay following a 25-year career with the defendant employer. We see this maximum being discussed in Master Schlosser's 2015 Alberta Court of Queen's Bench decision in O'Donnell versus Soldan Fence and Metals 2019 Limited, where he stated that, quote, "The ceiling is about 24 months. A 24-month notice period is said to be reserved for, quote, senior employees and managers with significant responsibilities," end quote. Citing Nowakowski versus Canadian Linen and Uniform Services Co. Naturally, the employer is going to be pushing back against providing its terminated employees with the higher end of these notice periods, and thus severance pay, especially in the initial offer that is put forth, such that seeing the initial offers of only 1 or 2 weeks notice per year of service with sometimes plausible arguments for those lower offers, and certain employers provide little or nothing more than the statutory minimum of termination pay in lieu of notice, is the reality that most fired and terminated employees face. This in turn leads to the need for further investigation analysis specific to one's individual employment circumstances, so as to determine how best to approach one's personal situation when fired or terminated from your job, and needing to assess the adequacy of the severance pay being offered by your former employer. Thank you.